All right, this is the business law chapter summary for chapters 18 and 19. Chapter 18 starts off talking about the administrative law, the procedural rule, substantive rule, and the administrative agency, which ties into all of those. It continues on to talk about the independent administrative agency and the executive administrative agency. And it goes on to talk about reasons for growth are flexibility, need for expertise, prevention of overcrowding in courts, and expeditious solutions to national problems. Talks about enabling legislative power, and executive power, along with judicial power. So it goes into more of like the three branches of government and what they do and like what all entails with them and the courts. It talks about the Administrative Procedure Act, or APA, which is the law that establishes the standards and procedures that federal administrative agencies must follow in their rulemaking and I have no idea how to say that word, educative functions. And it goes, steps in rulemaking process are agency draft rules in consultation with interested parties. Proposed rules are published in Federal Register. Interest parties can file written comments on the written draft, usually within 30-day period from publication in the Federal Register. Final draft of a rule is published in the Federal Register 30 days before it takes effect. A statement of its purpose and cost-benefit analysis must accompany its publication, and agency receives feedback from interested parties during the 30-day period and makes a decision on whether the final draft should be written. If not, it becomes law. It goes into the steps of the education and judicial review of agency decision making. And it finishes off the chapter talking about consent order, administrative law judge, ALJ, and preponderance of evidence, which is a legal standard whereby a bare majority, 51%, of the evidence is sufficient to justify a ruling. And Chapter 19 talks about the Workers' Compensation Laws, the Family and Medical Leave Act, which is FMLA, and it talks about the policy must provide all eligible employees with up to 12 weeks of leave during a 12-month period for any of the following family-related occurrences: the birth of a child, the adoption of a child, the placement of a foster care child in employee's care, the care of seriously ill spouse, including same-sex spouses in those states that recognize same-sex marriages, a parent or a child, a serious health condition that renders the employee unable to perform any of the essential functions of his or her job. Talks about the Occupational Safety and Health Act, or OSH Act, is a regulatory act designed to provide a workplace free from recognized hazards that are likely to cause death or serious harm to employees. And the OSHA, which is Occupational Safety and Health Administration, which is the agency responsible under the OSH Act for setting and enforcing standards for occupational health and safety. Talks about the establishing health standards in the OSH, and the OSHA has used a following four-step process since 1981. The agency asks whether the hazard presents a significant risk that warrants intervention. If it does, OSHA decides whether regulatory action can decide the risk. If it can, the agency establishes a standard to reduce the risk to the extent feasible, taking into account both technological and economic feasibility. OSHA then analyzes the cost effectiveness of various implementation options to determine which will achieve its goals most effectively. And then it finishes out the chapter talking about the steps of steps of a consultation adapted from the consultation program for small businesses, which is step 1, walkthrough; step 2, opening conference; step 3, initiation; step 4, abatement and follow through; and step 5, closing conference.